How do I prove undue influence or lack of capacity when a will or deed was signed? You usually prove these claims by building a detailed timeline focused on the exact day the document was signed, what the signer could understand then, and who controlled access, information, and the signing process. Lack of capacity is about the signer's mental ability at the moment of signing, not just whether they had a diagnosis like dementia. The strongest proof is specific. Could the person explain what they owned, who they wanted to receive it, and what signing would do? Undue influence is different. It is about whether someone else's pressure or control overpowered the signer's free will. Direct proof is rare, so the case is often built from circumstances, like isolation from close family, a sudden major change from a long-standing plan, disinheriting expected heirs, benefiting someone outside the immediate family, and whether the beneficiary helped arrange the lawyer, transportation, witnesses, or notary, or was present in directing the process. For a will, this is commonly raised by filing a will caveat in the estate file with the Clerk of Superior Court, and it is then transferred to Superior Court for a jury trial. There is often a deadline, generally 3 years after the will is probated in common form, with limited extensions for legal disability. For a deed, the challenge is usually a civil case affecting title, but the proof themes are similar: capacity at execution, whether the transfer was fair and voluntary, and whether the person receiving the property participated in or knew about improper pressure. Because later transfers to an innocent purchaser can complicate what remedies are available, it is important to act early, preserve records, and identify the witnesses, notary, and medical and caregiving records tied to the signing date.